before we press on, I've been petitioned by all those around me to ask whether we might be permitted to remove our wigs and gowns, because it is rather hot down here.
Of course you may. I was just making sure that I'd heard you correctly.
Nothing else to be removed, thankfully.
Yes.
So, my lords, then moving on to the second big topic, which is that of lack of technical contribution, arbitrary selection. And as I mentioned at the outset, the judge held that the patent was also invalid as being an arbitrary selection from the earlier prior art application W0128. So can I start by showing your lordships that briefly? So that's the supplemental bundle in tab 5. And if we go to the first page of text of that, so that's page 37 of the bundle, we see the field of the invention is the same as the patent. The present invention relates to CRL glycosides, which are inhibitors of sodium-dependent glucose transporters found in the intestine and kidney. And then there's a section of background information, and what we see on page 8 of the document, 44 of the bundle, are that in contrast to the patents where there was just a single molecule, here we have a generic formula that has multiple options. So for my lords who perhaps haven't seen one of these before, where there's the little R1, R2, R3 and 4, so on, poking off parts of the molecule, if one flicks over the page, you can see that there's a whole range of different possibilities that those substituents in the molecule can be. And it was common ground that the coverage of this formula was vast, into the billions of different permutations and combinations. There are then some narrower formulations. So if my lords go to page 47 of the bundle, there is a formula down the bottom called Formula 1A, and that is a bit more restricted than Formula 1. And similarly on page 12 of the document, 48 of the bundle, the structure 1B, which is even more limited. But as the judge held in paragraph 169 of the judgment, it was still common ground that even Formula 1B covered millions of different permutations of molecules. So whilst the the prior art states that the compounds of each of those formulas are have activity as inhibitors of sodium-dependent glucose transporters. Again, there's no data in this document for any of them. We can then turn on to page 52 of the patent, which is page 88 of the bundle. And we see in the middle of the page assay for SGLT2 activity, and it is correct, as others may have gathered already, that that's the same text in the prior art as we saw earlier this morning in the patent. Now then, from over the page on page 89 of the bundle, the patent then has, this patent, 128, has a series of example compounds and methods of synthesis of those, and there are 15 that have detailed descriptions of their synthesis, none of which are dapagliflozin, and that runs all the way through to page 98 of the patent, which is 134 of the bundle. And then after that, then in more succinct form, there are a series of different further examples given all the way up to number 80 at the end of that long table. And again, none of those compounds are dapagliflozin. And so this document does not disclose dapagliflozin, best one can say is that dapagliflozin falls within the generic structure of each of those three formulas that we looked at, but hasn't been, to use the phrase that the EPO would use, hasn't been individualised and expressly disclosed. Now, with hindsight, if we go back to example 12 on page 123 of the bundle, we can see example 12 there, and that is the closest molecule that there is to dapagliflozin. Dapagliflozin, I'm sure my lords have got a picture of that firmly in mind. It's the same as example 12, except rather than having an O-methoxy, top right hand corner, dapagliflozin has an O-ethoxy. And the claimants ran a conventional obviousness case that it would be obvious to look at example 12 and to make the dapagliflozin in the light of that disclosure, but that argument didn't survive the evidence and they abandoned it before closing. So there's no finding that a skilled person would look at this document and have any reason why they would make dapagliflozin from it. But nevertheless, the judge held that this document rendered the patent obvious because it lacked technical contribution. So can I now go to the law on this, and can I show my lords the Dr. Reddy's case from this course? So that's in the first authorities bundle at tab 6. And the same kind of argument was run in this case as is being run, Dr. Reddy's is being run in our case. So we can pick it up at paragraph 17 on page 239. And there's a heading just above the middle of the page that says what 235 discloses. Now 235 in this case was the prior art. And as Lord Justice Jacobs says here, the prior art had in paragraph 18 a so-called Marcouche formula that sets out possibilities. They are vast. Formula 1 includes at least 10 to the power of 19 compounds. And then he then goes on to say there's a narrower class, that's still very large. It also names 100 compounds but gives no indication that any of them have been made or tested. And it says nothing about them other than making a broad assertion of utility. And over the page on 240 of the bundle, Lord Justice Jacobs says the statement is mere assertion, unsupported by experimental evidence. The skilled reader is quite unable to decide whether the assertion is true or soundly based or plausible. So then if we turn over to page 242, Lord Justice Jacobs starts by dealing with the obviousness case, and initially he deals with the old-fashioned English approach, which was called selection patterns, but we can forget about that because he then went on to consign those to the dustbin of history. And in paragraph 40 of the judgment on page 243, he says, so I think the better approach is to see what the EPO boards do when a patented product or class of products falls within a greater class. They deploy the objection of obviousness where the patentee has in truth made no real technical advance. And as we'll see through this judgment, whether a real technical advance has been made is the touchstone for inventive step. And in 42, he talks about an issue about the time between the prior art and the patents. But in 43, he says another matter that comes into play on the question of obviousness is the nature of the information in the prior publication. Is it likely to be read by the skilled person as conveying serious technical teaching, which he or she will take seriously and expect to be true? Or is it no more than an substantiated speculation? If the latter, then the skilled person is far less likely to do anything with it, and specifically identifying a compound and showing its utility is much more likely to be inventive. So making it clear that the nature of the prior art disclosure becomes relevant to asking a fundamental question: has there been a core has there been a technical advance? And he goes on in paragraph 50, having looked at some EPO authorities, to explain again what the key test is. He rejected the submission that the EPO jurisprudence has recreated the selection pattern rules. He said, I do not accept that. The EPO jurisprudence is firmly founded on the fundamental question, has the patentee made a novel, non-obvious technical advance and provided sufficient justification for it to be credible? That's the basis of the reasoning. And when he came to look at whether that was the case in this case, one of the factors he took into account in paragraphs 56 and 57 was the vagueness of the prior art. Perhaps my lords could just skim read 56 and 57. So the point the judge is making there is that if the prior art doesn't give you any idea how any of the individualised members may behave, then it's difficult to say that one compound out of that class is obvious in those circumstances. So just one more authority to look at, and I'm afraid that's in the other bundle, so bundle 2. Bundle 1 can go away. And this is tab 15, which is the first instance decision of Mr. Justice Mead in the apixaban case, dealing with this issue. So just for my lord's understanding of how it went, the point that we were dealing with this morning, the plausibility issue, was dealt with by the judge in Mr. Justice Mead in this case, and then went to this aspect. The lack of technical contribution was argued in front of the judge, who rejected it, but then it wasn't appealed. I just want to show my lords the reasoning in relation to that. So it's page 919 of the bundle. So very similar factual situations both to Dr. Reddy's and R1 here. The prior art had a wide formula that covered apixaban, an assertion of activity, but no data in it. And at 237, the judge says, in identifying the relevant disclosure of 131, I've pointed out that it contains the same teaching as, and sorry, I'm going too fast. 131 in this case is the prior art. 652 is the patent, so I'll try and use those terminology. In identifying the relevant disclosure of the prior art, I've pointed out that it contains the same teaching of the patent in relation to utility, whether in terms of factor 10A, inhibitory activity, therapeutic or non-therapeutic uses. However, that teaching is referable to different classes of compound than in the patents, and while the classes cover apixaban, they don't disclose it. He then notes that he's found that the patent lacked plausibility in its own terms. He says, but if, then in 239, if I'm right what I say about plausibility, then the patent is invalid anyway. The attack over the prior art would only matter if I was wrong about plausibility. Although the claimants maintain the attack over the prior art is a distinct one, I found it hard to see how a realistic scenario in which it would succeed if the plausibility attack failed. In the end, I think their point was that that if the patent were to be plausible based purely on the teaching of what was in the prior art, albeit by reference to the different classes of compounds, then the plausibility attack would fail, but the attack over 131 would succeed, because there can be no invention in just picking a different compounds within the prior art. However, I can't see that there's any realistic way in which the plausibility of the patent could succeed based purely on teaching that is in 131. I do not think it was even argued. Bristol-Myers' case depends on the patentee in the patent having named apixaban as a specific compound, which had been made in quantities such that it could be inferred that the patentee thought it was promising, bolstered by it being a typical lactam. That information was not in the prior art, nor was the structural case, of course, from the CGK. Sorry. That information is not in the prior art, nor is the structural case in 652, of course, it's from the CGK, as I explained above. So what the judge saying there is that had he been wrong on plausibility, because the teaching in the patent is very different to the teaching in the prior art, he couldn't see how the attack of lack of technical effect could have ever got anywhere. And as I say, that finding wasn't then appealed to this court. And so we obviously commend that as the correct approach to cases of this nature. So can I then turn to the judge's judgment? He dealt with this in two halves. First, when he came to deal with the law, he reviewed the relevant authorities starting at paragraph 39. So core bundle tab 5, paragraph 39. And what I would like to show your lordships is just his overall approach that he said he was going to apply, which one can get from paragraph 59, which is page 22 of the judgment. So the key point here is the judge is setting up a test where one's comparing what is said about a previously disclosed genus of compounds in the prior art as compared to the patent. And what we say he's overlooking here is the points that I showed you in relation to Dr. Reddy's about the nature of the prior art and how seriously, to use Lord Jacobs, or Justice Jacobs' expression, the skilled person would take that teaching. So when we come to look at his application,
can you just pause for a second? What is to be attributed to the use of the word individually in the penultimate line? To those individually, because he's talking about
the specific
a later selection of an individual out of a group, and I don't at the moment understand why previously individually disclosed.
I think he's saying comparing having different or improved property compared to the compounds that were specifically identified in the prior art.
Because it must mean something more than just the group.
Well, the thrust of the basis for this kind of an argument goes along the lines of when someone's disclosed a class of compounds that have a particular property, merely picking one of them and finding it has that property doesn't give you is not an inventive step. So
if you're going to select a compound, which on the face of it is within the broad definition of the early one, you need to demonstrate that not all of the prior disclosed compounds, the 86,000 or whatever they may be, plausibly have the same effect.
Well, you need to ultimately make a technical advance, and let me illustrate that in two ways. It may be that if you have a prior art document that's got a narrow class of compounds, there's data showing that a good number of them across the width of that class have the effect that's claimed on them. Then it may be that the skilled person thinks, well, I think all of them are likely to have that property. Mm-hmm. And so merely picking another one with that level of activity might not be a technical advance. Mm-hmm. However, at the other end of the scale, you may have a very wide formula, no data put forward, maybe a few islands of activity, but no reason to know which of the other ones do and don't work. In those circumstances, we say that there may be a technical advance in finding one that works when that piece of prior art doesn't give you any assistance to find it. So that's why it's crucial to understand what the prior art is and the quality of the prior art disclosure. And the higher the quality of the prior art disclosure, to make a technical advance, you may well have to show an improved property. But we say the judge, where we'll come to see in a moment, where he fell into error was thinking that you always had to show an improved activity over what the prior art said the other molecules had.
I don't think you're answering my Lord's question, so let me offer an answer and see if you agree with it. What he's doing is paraphrasing what's in the guidelines, which are quoted at paragraph 57, and specifically paragraph B, where the guidelines say advantageous properties is compared with the compounds specifically referred to in the prior art. And the point is that in a case, to take the facts of this case, it's not merely the fact that DAPAG is a selection from the class disclosed in W128. It is, as you've acknowledged, structurally very similar to example 12. So what he's saying is this: one tests the question of technical contribution by looking to see if there is some advantage, and I use that word advisedly because it's not the right word, but it's a convenient paraphrase, over the individual examples that are given in the prior art, specifically in our case, example 12. Now, you may say that's wrong, but is that a fair paraphrase or a fair explanation of what the judge is saying?
It's what the judge is saying. What we say is wrong in relation to that is that when the evidence is, I'll come on to the end of this aspect of the case, the evidence was that the skilled person understands that small differences to the structure of the molecule can make a huge difference. The evidence was you couldn't predict from any individual molecule that any other molecule would have the efficacy. And what the judge did was he mixed up issues of conventional obviousness with this kind of obviousness in reasoning from example 12 to saying therefore dapagliflozin was an arbitrary selection. But I'll come on to make that good in a moment. Now, so the judge dealt with this from paragraph 263 onwards, and we pick it up at 268. He said he says that our technical contribution at trial was that it was an SGLT2 inhibitor that reduced blood plasma glucose and was useful for treatment of diabetes. But AZ did not advance the case that dapagliflozin was, in this regard, any different from the properties of the other compounds of W128, and in particular example 12. So what he's doing there is comparing what was said about those compounds in the prior art with the technical method that we relied upon. And therefore he said it doesn't make a technical contribution because it has the same properties. And we say what that overlooks and doesn't take into account is the nature of that prior art disclosure. So he then came on to address our specific case in 270. The argument advanced was that the patent made it plausible that dapagliflozin was an SGLT2 inhibitor that reduced and so on. And that was something new, and so was this technical contribution. That essentially is another way of putting the point that Lord Justice Jacob had made in Dr. Reddy's. The judge thought there was a bit of sleight of hand going on here, although he referred to the test of is it a technical advance from Dr. Reddy's, he decided that making something plausible isn't a technical advance. So he then went on to analyse the case on the basis that, on the assumption that the skilled person had found the patent to be plausible. The reason being, of course, is that if the patent was implausible, then the patent was already invalid. And what he said in 273 was then, in my judgment, 128 must also be understood as disclosing that the compounds which it discloses have been assayed and been generated and had the relevant properties. And he referred to some evidence from Professor Potter, who was our medicinal chemist. And Professor Potter had said, he'd assumed that at least the examples would have been tested. And then in the quote in 275, do not believe the medicinal chemist have any reason to doubt the assertion that the class of compounds do inhibit, albeit it may not expect all of the very large number of the compounds to have this effect. And based on that, the judge then went on, perhaps if my lords maybe just read, rather than me reading them out, 276 to 278, and see what he said.
So your submission is that the judge was wrong to accept your expert's evidence?
Well, my lord, it depends what that evidence was, that the examples have been tested and found to be active. Other ones would also be, but not all of them. So what there wasn't a finding of, and I'll come on to develop this, is that the skilled person would have any idea which of the non-examples within the formula would be active and which ones wouldn't be active. And we'll see that both sides' experts essentially said this pattern teaches you nothing about which ones are active, and you'd have to do your own SAR studies. You have to do your own work to find out the ones that are active. And of course, what the patent gives you by way of a technical advance is it gives you dapagliflozin on a plate. It means you don't have to go away and do that structural activity and relationship work, and that's why it comprises a technical advance. Well, that's the case in two sentences. So what we say is, when the judge looked at this issue, is first of all, he didn't take into account the width and the broadness of the prior art and the lack of any useful information as to which compounds in that are what the skilled person would think of. Effectively, he took the approach that as long as the prior art says the compounds within Formula 1B are SGLT2 active inhibitors, that's enough, and there's no scope for any invention in identifying which ones of those are and aren't inhibitors. So, for example, that would mean that a broad assertion about, take a different example, that a huge class of molecules were useful for treating cancer would prevent any of those compounds, perhaps after long amounts of work, being found to be useful to treat cancer, ever being patented. Yes, and of course, although in this case the prior art is a patent, prior art can obviously be journal articles, it could be things in trade magazines and the type. It needn't all be of this nature. And so we say, when properly analysed, the patent doesn't inform the skilled person which of the very large number of compounds in Formula 1B are and aren't active. All it gives the skilled person are islands, which are the examples, and those are isolated data points. So to use an analogy, it's rather as though someone's gone to a ploughed field and said, I've put 50 gold coins in this field. There are 10 of them sitting on the surface, but the other 40 are buried. knowing where the ones that are sitting on the surface are doesn't give you any assistance in finding out where the buried ones are. And so you can see the ones on the surface, can't see the buried ones, and then so we say there's plainly scope in a case like that for a technical advance in identifying one particular compound that hasn't been pointed to at all in the prior art, that in fact has the beneficial property.
I'm sure this is very non-technical, but I'm just struggling to understand the basic idea. Is this right? For a selection from a prior group to make a technical contribution, it must be shown that the prior group did not disclose the technical contribution.
No, it has to make an advance, technical advance over that prior class that's disclosed.
That's what I was trying to get at, that if the technical contribution's already been made by the prior selection or group, or however you'd like to describe it.
Yes, and so you may have, as I said, you may have a technical advance by showing that one particular member has got different or improved properties, on the assumption that the skilled person thinks that across all the members of the class they will all have the property that the prior asserts they have. Or in a different case, if they don't think that it's likely that all those molecules in the prior class do have that, and they understand that some will and some won't, but they don't know which, then we say there may be a technical advance by identifying the ones that which do have it. All comes back to that touchstone of has there been a technical advance.
Thank you.
So now, as we saw, the judge approached it by saying, well, if the skilled person thinks the pattern is plausible, then he would think the same in light of the prior arts. And as we say, the position isn't so straightforward. So no witness took the view that all the molecules within Formula 1B would be SGLT2 inhibitors. My own friends' witnesses took the position that absent any data, there was no reason to think that any of them had the activity. They were focused on, is there any data? Without data, no reason to think. And as we saw from the judge recording the evidence, my witness, Professor Potter, thought that the examples had been tested and found to be active, and that other ones would be, but not all of them. And the judge didn't find, and no witness said, it was known which of those other ones, other than the examples, would have been active and which ones would have been inactive. And it was common ground amongst the medicinal chemists that small changes to a molecule would make a big difference to their activity. So whereas as a layman we could look at two molecules and go, well, there's not much of a change there, the medicinal chemists tell us, they told the judge, that life is not so straightforward in chemistry and biochemistry, and even changing one thing that's quite small, that could make a big difference. And we've given the references in our skeleton to where the claimants, experts, made that point repeatedly, which I'll take you to. But what I would like to show you is what Dr. Edwards, their medicinal chemist, said about what you learned from this and what you would need to go forward. So can we take the supplemental bundle and go in that to tab 14. And go to page 205 internal, which is 245 of the bundle. And we see at line 5, Ms. Lane says, I'll move forward now to page 55 where the document sets out the working examples. And I think you agree that those examples have been synthesised. Yes. And that's just giving my lords the bearings about what we're talking about. And then over on page 206, she says, that's the most sensible reading, line 13. That's the most sensible reading of this document, is it not? Which is all about SGLT inhibitors and sets out an assay to test it. It's just completely lacking in common sense that you would make 80 of them when you've not tested them. The witness says maybe they're making compounds to substantiate the scope to stop others encroaching. It does not mean these compounds were tested. you're not prepared to accept things in the patent at face value, you're sceptical. I am sceptical. And then she asked a question at the bottom of that page, whether the skilled person would think, given the number of compounds, that was done for the purposes of generating a structure-activity relationship. And so perhaps could my lords just read from there down to line 19 on page 207. So the point the witness is making there is there's nothing in the prior art that provides any insight into the relationship between structure and activity, and it's impossible to deduce that from what they've done. And then one final reference on page, internal page 228 on page 249. Now this is when they were, to be clear, this is when Miss Lane and the witness were dealing with conventional obviousness, which is also relevant to this issue. And the witness had identified, as we see at the page 228, line 7, about 30 compounds that he said would be the starting point for further work. And then if my lords drop down to the answer the witness gave on page 229, line 19, perhaps my lords can just read that over to the top of the page 230, line 2. In particular, with the witness saying you get told nothing from the patent, so you use your own intuition as a skilled medicinal chemist to come up with a rational design based on the pharmacophore. So that's Dr. Edwards saying you learn nothing about the other compounds from this patent. You have to do your own work and go and find it. And we say that's why the identification of dapagliflozin is a real technical advance. And the judge's reasoning in those paragraphs of the judgment that we saw, that the skilled person would think it was equally likely that all the compounds falling within the scope of the formula would be effective. And in particular, the analogy he did with example 12 wasn't supported by the approach that the experts had taken. And he was introducing issues of, we would say, conventional obviousness by comparing dapagliflozin with example 12, particularly in circumstances where the obviousness case based on example 12 had been abandoned. So this is not, most definitely not a case where the skilled person learns nothing more from patent that they learned from the prior art. They learn something new and something important, that dapagliflozin is an SGLT2 inhibitor. Now, two more points on my note now, my lord. The first one I think I've dealt with, which is my learned friend's submission that there always needs to be an improvement in properties over the prior art, and I think my lords have my submission on that. The last point is the impact of what we were talking about this morning, G2 of 21. So my lords will recall when we looked at the Dr. Reddy's decision this afternoon that Lord Justice Jacobs said there has to be a real technical advance and that has to be made credible by the specification. Now, so far we've been dealing with the issue of lack of technical contribution on the same basis that the judge has dealt with, which is that on the assumption that the patent has been found to be plausible. But it's possible that if my lords are against me on grounds 1 to 3, but with me on the issues of law we dealt with this morning, then the patent can still be not fall for lack of plausibility and not matter that it doesn't doesn't provide in its disclosure of the specification enough information to make it ab initio plausible that dapagliflozin is a SGLT2 inhibitor. Now, what we say in relation to that is that what one shouldn't do in those circumstances is take the comments in the Dr. Reddy's case and reintroduce the requirements of ab initio plausibility via arbitrary selection. And so that statement of the law that it has to be both a technical advance and made credible by the specification has to be seen in the light of more recent developments, and in particular G221.
So let me see if I've understood that submission. If I've understood what you just said correctly, what you're saying is that a decision of this court saying that we should not follow our old law, but should follow the law established by the boards of the EPO, we should now not follow because of the case law of the boards of the EPO.
Because, my lord, case law is a living thing, and it's moved on in this respect since the authorities that the court was looking at in Dr. Reddy's.
Kind of reduces the doctrine of precedent in this area to a vanishingly small point, doesn't it?
Well, no, my lord. I mean, the overriding principle is that we should be following the approach of settled approach of the European Patent Office.
Yeah, but what it means is we can forget about the question of whether there's binding precedent of the Court of Appeal before we just follow whatever the EPO is currently doing.
Well,
that's the logic.
That is the effect of activists and Merck, my lord. Yes. If it's settled, my junior is keen for me to say that. So it's obviously, and we aren't submitting that every decision of the TBA allows us to flip-flop around between different approaches. There has to be a settled approach, and the reason why the requirement for a settled approach was included in activism was precisely for that reason, that we didn't blow with the wind as the EPO does. But once it's clear that there is a settled approach, because of in this case, enlargeable decision, then we should be following that, because we're meant to be applying the same treaty, the same legal principles as they are.
Yes, but the point of asking the question is this, and I want to be crystal clear. As I understand it, on the relevant hypotheses, you are not asking us to depart from one binding precedent, you're asking us to depart from two binding precedents, viz. BMS and Dr. Reddy.
I think strictly, my lord, for the same reason in each case.
Yeah, it's the same reason, but that's what it comes to.
Yes. Yes. I mean, my lord, an alternative way of looking at it is when Lord Justice Jacobs said credible in Dr. Reddy's, what that means in the light of G2.
Was not incredible.
Not incredible, or has been made credible by post-file data.
I think he would have been astonished at that proposition at that time, but there we go. As you say, the case law has moved.
Yes. My lords, unless I can assist you further, those are my submissions.
Most Chancellor, thank you very much indeed to you and those who supported you. Yes, Mr. Mitchell.
My lords, taking matters in the order that my learned friend dealt with them, grounds 1 to 3 represent AstraZeneca's attempt to recast the evidence and re-argue afresh the issues which took up most of the time at trial. In our submission, this is an illegitimate attempt to persuade you to come to an alternative conclusion, de novo, when the judge properly took into account what he'd heard from the experts. It's common ground that a patent has to be interpreted through the eyes of the skilled person and in the light of the common general knowledge. And so, where there is technical material in a patent, evidence is admissible from experts going to that technical material, and in particular in this case, relating to the nature of the assay and the range of possible results which you might obtain from an assay of this sort, which particularly the biologist experts were particularly expert in. And as my learned friend himself accepted on his feet this morning, the witnesses are there to give technical context, and technical context is required for the court to interpret the specification through the eyes of the skilled person in the light of the common general knowledge. So we say the judge was fully entitled to take into account the evidence given on behalf of both sides as to how the skilled person would understand the disclosure and what they would expect from a technical perspective at the time. And we note there's no challenge to the judge's identity of the skilled team, and in 205 of the judgment, the judge found expressly that the skilled biologist in the relevant team would have a background in biology, in the biology of the target, and an understanding of the relevant assays. So this is not just a matter of construction upon which this court can reach its own view, unfettered by the evidence. We say the judge was entitled and indeed was required to take account of the evidence before him, and in any event, we say, the judge reached the correct conclusions for the reasons he gave. So if I can turn to the individual grounds 1 and 2, ground 1 goes to the issue of whether the reader of the patent would understand that DAPAG had been tested at all when no results whatsoever are provided in the patent. And in our submission, and the judge agreed, the failure to provide results, if they existed, is absolutely baffling to the reader. Because in the absence of any results, all the reader is given is an assertion that DAPAG is an SGLT2 inhibitor, and an assay by which they can test that assertion, i.e. they're set a project to do. And the evidence of our biologist expert, Professor Torrens, was that the patent required the reader to make a leap of faith because the patent did not contain any results, and the reader was in no better position, having read it, to know whether or not DAPAG was an SLG2 inhibitor or not. Now, the judge dealt with this at 235 of the judgment onwards. If I can take you to that, please. It starts at page 88 of the bundle. And first of all, the first thing he does is he analyses the language of the document. And he's plainly correct to point out that when in paragraph 114 of the patent, this is paragraph 238, all that says is that the activity of the compounds of the invention may be determined. So it does not say that it has been determined. And in our submission, as the judge correctly found, this is a disclosure of how the compounds of the invention can be tested to see whether or not they have SGLT2 inhibitory activity at all. And it is no more than an invitation to the skilled reader to do that. The judge deals with the disclosure of 115 in 237. That's the assay itself. And he points out, which is not contested, that when the assay refers to, it's written in the past tense, and when it refers to a molecule to be tested, it just refers to the word inhibitor. It doesn't refer to DAPAG at all. Now, my learned friend this morning said, oh, well, if it refers to inhibitor, that would be understood to be DAPAG, because that's the only inhibitor mentioned anywhere in the patent. But that's not right, because the patent mentions fluorescein as an inhibitor. It mentions the molecules of W128 as inhibitors, and it mentions the T1095 Tanabe molecule as an inhibitor. So there are numerous inhibitors referred to in the specification of the patent, and it's just not the case that you can say that where the assay refers to inhibitor, it must mean DAPAG.
Why would it refer to anything else?
For the reasons that the judge accepted on the evidence, that the assay, because it doesn't say that the assay has been carried out on DAPAG, it says an assay has been carried out, but the inhibitor referred to in that assay could be florozin, it could be one of the molecules.
I was asking why it could be.
Why? Because the evidence was, and I'm going to show you that evidence, was that in order to validate these assays, you have to do them first on something that you know is going to be an inhibitor.
But that's, if you're only talking about a preliminary assay to test your assay, that's of no significance at all, is it?
Well, if
forgive me for having a very basic level of understanding, but just as a matter of English language, this is all about what I'm going to call dagger, if you'll forgive me. This is all about dagger. Paragraph 114 says you can test its efficacy or whatever it is in this way, and then it says an assay has been done. Why would it be talking about anything else?
Because in order to test any of these molecules, any inhibitor of SGLT2, you have to validate the assay. And all that paragraph 115 says is that an assay, here's an assay that works. It's referred to in the past tense, we accept it's been done on something. But it doesn't tell you whether it's been done on DAPAG or on one of the WO128 molecules, or indeed just on florozin.
Forgive me for not understanding, and I'm sure it's my lack of understanding. It would be nothing to the point to just describe an assay which was a preliminary assay of something else to test whether an assay works. In the structure of the patent, as I read it, it seems that the natural, it's a progression talking about the compound of interest. And I hear what you say, that you may need a different assay to test your assay before you test your assay on something else and so on and so forth. But why would you put that in as your sole reference to an assay? I think it's sole reference to an assay in that point in this document.
Yes, but the counter argument, which the judge agreed with, if you had tested DAPAG, you would A, say you tested it, which the patent doesn't do, and you would B, put the results in, which the patent doesn't do.
Are there reasons why people don't put results in?
There were, well, to keep them confidential, they don't want the rest of the world to see them. That's one possible reason, but that wasn't explored before the court. We didn't try and run an argument as to why.
It's just not there,
just
for
not
reasons
there.
which were not explored.
For reasons which were not explored.
Okay, thank you.
And so, my lords, we say, as the judge pointed out in paragraph 239, the paragraph 115 doesn't tell the reader that the assay has been carried out on DAPAG at all, and no reasons of results of such testing are provided. And then 239 goes on to contain an important finding based on the expert evidence. Because what he says is, further, I accept the claimant's submissions supported by their cross-examination of Professor Bailey, that the skilled person reading the patent would understand that the assay could have been performed by the patentee on other compounds, either in the validation of the assay, in which case florozin might have been used, or in assessing the SGLT2 inhibitory activity of other compounds. So there he has made a positive finding, based on the expert evidence, that the reader might well think that when 115 says the assay has been performed, it was in fact not on DAPAG, but on alternative compounds. And the reasons for that are as follows. The judge introduces the concept of validation of an assay in paragraph 83, and that's part of the common general knowledge. So it wasn't in dispute that there's a requirement to do a validation. And then there were various passages of cross-examination on this, as the judge has expressly referred to in 239. So if I can pick it up, please, in the supplementary bundle at tab 17. And the first passage is on, starts at the bottom of page 278 of the bundle. and this is a passage, I don't need to labour this point because this passage was shown to you by my learned friend this morning. So it's bottom of 278, and then it's bottom of 562 in the transcript, and then 563 in the transcript. And my learned friend showed you that this morning. So that's one part of the cross-examination. And we note, your Lordships will note in line 3, where Professor Bailey is answering me about the assay, he uses the word of paragraph 115, inhibitor. So he's accepting there that inhibitor covers all these other molecules, including fluorescein and T1095. So that's one passage. Then I go on to put to Professor Bailey the Ryan paper, which is the piece of art that the patent refers to as just telling you about the assay. And that's the cross-examination going on the rest of this page of the transcript. And then I come back, that finishes on page 281 of the bundle, at page 572 of the transcript. I say last question on the Ryan paper at line 9. I say here, it's only fluorescein that's being tested, yes. I would need to check that, but on the illustrations it was just fluorescein, yes. Yes, which might be another reason, if you went to this, that is to Ryan, to test fluorescein first to try and reproduce it.
It's my fault.
Yes.
I haven't found the passage.
Sorry, I'm on 572 of the transcript.
Yes.
And it's line 9. Here it is only fluorescein.
I see. Yes, thank you.
So if the skilled person went to Ryan, then Professor Bailey agreed that that would be a further reason to test fluorescein, because in fact the only thing that you test in the Ryan assay is fluorescein. I also asked...
There's two different questions, aren't there? I mean, one question is, what would the skilled person do if the patent is put in front of them, and they're interested in putting it into practice? But then the question that's more relevant for our purpose is what does the skilled reader think has already been done?
Yes.
And I assume you would accept that the answers to those two questions are not necessarily identical.
Correct. Of course, that might be a different, but at least Professor Bailey there is accepting that if you go back to Ryan when you read the document, and one of the experts thought you would, Professor Torrance thought you would, and Professor Bailey didn't think it was necessary. But if you do that, you see that they test fluorescein, and that's a further reason to think that the inhibitor in the assay that's referred to in 115 might be fluorescein. Now, the other passage of cross-examination which my learned friend didn't take you to, I do need to show you. So this is about the wording in the patent and the continued reference in the specification of the patent to inhibitors, plural, even though only one compound is ultimately claimed in Claim 1. And I asked Professor Bailey about this, and if we can pick it up on page 288 of the bundle, and if we pick it up, please, at page 599 of the transcript, and at line 7, Professor Bailey said, well, he thought the reference to inhibitors, plural, might be a typo. And so I said to him, line 7, even if you're right that it's a typo, Professor, just go back to the front of the patent, the very first page. Can you see the title is SGLT2 inhibitors, plural? Yes, I can. Then if you go to paragraph 1, can you see it says we have the same inhibitors, plural, but we also have the statement, the present invention relates to C-aryl glucosides, plural. And so I've asked him, pointed out where the different references to inhibitors come from. And then perhaps if your Lordship would just read down from page 19, line 19 on 599 to line 23 on 600, please. So having established that the skilled reader who is entitled to take into account the fact this might be a follow-on patent or a divisional, that's established by the Virgin case. I then ask him about the assay on page 602, and if your lordships will just look at the text, 602 line 19 to 603 line 9, please. So, my lords, we say this is further positive evidence before the judge to establish that the skilled reader might well think that the inhibitor in paragraph 115 was in fact one of the previous molecules, or florazin, not dapa, the subject of this patent.
So you say whether that's right or wrong, sensible or insensible, it's evidence which the judge was entitled to accept.
Indeed, and he said expressly he was
And he
relying
says he does.
in part on that, yes. We also have the passage that my learned friend took you to on page 291 of the bundle, and this is on page 611, 612. Again, I don't need to read all that out to you, you already looked at it. And indeed, it's quoted at 256 of the judgment. But we do rely particularly on the question and answer at line 22 to 24, where I say, you just do not know what has been tested in the assay in the patent, Professor. And he says, you are correct, but I do not know what was tested. Yes. So the argument that my own friend tried to run this morning to say, oh, well, even if he agrees that other things have been tested, he's not suggesting that dapa wasn't tested, is completely contrary to the evidence given there. He's clearly saying there he doesn't know what's been tested. He's not suggesting dapa has been tested. There was no re-examination of Professor Bailey to say, oh, well, when you said you had no idea what was being tested and you considered that other things might have been tested, you weren't suggesting that dapa wasn't tested, were you? That was never put to him. And so my learned friend's submission, I'm afraid, fails at that very basic level. So, my lords, we say the evidence all went one way as to what was being referred to in 115 by the reference to inhibitor. Now, it's right that Astrazeneca no longer rely on their own expert evidence in support of the judge's findings on plausibility, because they're now constrained to say that it's just a matter of construction. So it may not matter, but we note that the judge found reason to discount that in paragraph 240 of the judgment, where, and again that was based on cross-examination, where he said that the AstraZeneca's experts were misled by their reliance on the fact that this material was found in a granted patent. Somebody even said it had, it's got a well-known pharmaceutical company on the front of it, so it must be true. And of course that is legally irrelevant, and the judge accepted that. And so that completely cuts away any reliance, even if my own friend was entitled to, on his own expert evidence. And indeed, the passages of cross-examination which support that finding in 240 even included a passage where I put Professor Potter the possibility that BMS might have filed 50 patents for individual compounds at the same time as DAPA, but withdrawn 49 of them before publication, leaving us only with the DAPA patent as the one left proceeding to grant. And of course that's a possibility. There's no evidence that actually happened in this case, but it is possible to file a patent and then withdraw it, and a record is never made of that withdrawal. And so that shows how a patent system could be abused by only finding results after you file the patent and then deciding which of the patents you want to pursue only based on results found later, and that of course is a recipe for abuse and why the first to file system, we say, is so important and runs through the case law that we'll come to later. The final point that the judge relied on was the abandonment by Professor Potter of his reliance in the oral evidence on the 20 grams of DAPA that was made in the patent, and he readily accepted once he was cross-examined that couldn't tell you anything about whether or not it had actually been tested or its characteristics. And that, of course, is a further distinction with the apixaban case, where the weight of the material in that case has been taken into account. It was taken into account by the English courts, but certainly it was taken into account by courts abroad. So, my lords, in summary, we say there was plainly technical evidence before the judge about the disclosure, which he was entitled to take into account in coming to his conclusion. There's no basis to interfere with the conclusion he reaches in paragraph 241. Indeed, he was right to reach that conclusion. And we note also at this stage, there is no challenge to the findings which follow in 242 onwards about the structures. And again, that's all based on the expert evidence. And we will have to return to that briefly when we come on to my learned friend's sixth ground of appeal on the plausibility standard. So, well, that's ground one. Ground two is my learned friend attacks the finding of the judge in 232 of the judgment that the SGLT2 inhibitor in the patent must have sufficient efficacy to treat diabetes. And that's the starting point in the judgment. And my learned friend has to seek to undermine the complete absence of any potency results or any evidence as to what potency level was reached in order to establish that even if DAPA had been tested pursuant to his ground one, it also achieved a sufficient level of efficacy or potency to be efficacious to treat diabetes. The judge also made findings based on the possible use of DAPA as a tool, but as your lordships have not been pressed on that by my learned friend this morning, and the findings are the same, that there wasn't sufficient efficacy for a tool either, I think we can take them together, and I won't trouble your lordships further on the tool aspect. So the problem for Astrazeneca is that even if the reader of the patent believes DAPA was tested, there is absolutely no teaching anywhere in the patent as to what efficacy level is required, or that this efficacy is achieved for DAPA. So AZ has to resort to trying to pull itself up by its own bootstraps and say, well, it must be efficacious enough, otherwise the patent wouldn't have been written. But there's no basis for that, and indeed the fact evidence and the expert evidence went the other way. And it was, to be noted, it was never part of AZ's positive case on the evidence that the skilled reader would ever know what potency level was needed or what the potency level of DAPA actually was. So it is a black hole in terms of evidence, positive evidence and a positive story from AZ. There simply is nothing to tell the skilled person what level is required, and that's a further fatal problem for the disclosure of this specification. Now, as far as the judge dealt with it, he started with it firstly making general findings about potency levels, and you can see that findings on the common general knowledge are in paragraph 102 of the judgment. And there he explains that there may be a cut-off of 10 micromolars in vitro assays, but even compounds with this level of IC50 would not be regarded as acceptable as a drug. For that, medicinal chemists would generally be looking at IC50s in the low nanomolar range or better. So that was the common general knowledge. Then he goes on to deal with specific evidence about potency and SGLT2 inhibitors, and we can pick that up in paragraph 214 of the judgment, please. And specifically, the second sentence of 214, he finds, I think you've already looked at, he finds that potency for SGLT2 inhibitors was not known as part of the common general knowledge, and it wasn't known what would be required to achieve sufficient degree of SGLT2 inhibition to treat diabetes. There was some evidence which he addresses in 215 about the micromolar potency of a different drug, metformin, but as the judge finds, that drug doesn't work with the same mechanism and is not the same, even if the potency of metformin is in the micromolar range. That's not the same as saying what the EC50 of metformin is, and that whether or not the EC50 was micromolar or not. And it's important not to get confused between those two aspects, which the judge was clear to separate. And the final line of 215 is important because there the judge records the evidence of Professor Bailey that a compound with a millimolar EC50 would not be regarded as acceptable. So the evidence was before the judge that there were EC50 values that you could achieve by doing the assay, but that it is agreed would not be acceptable. They wouldn't be good enough SGLT2 inhibitors to treat diabetes. So there's an important finding there that separates the two grounds 1 and 2. Even if you believe, the reader believes that DAPA has been tested and an EC50 value has been achieved, if that EC50 value was in the millimolar range, that would not be regarded as acceptable and would not show sufficient utility. And so the judge concludes at the end in 218, if I can summarise his findings in 218, which you already looked at. He says potency is important for an SGLT2 inhibitor. The target was a nanomolar EC50. A millimolar EC50 would not be a credible candidate, and even if you wanted something as an experimental tool, you'd have to match the EC50 of fluorescein. The other paragraph, just to note in passing, we don't need to go to, it's 226, where the judge records that AZ did not suggest that any level of SGLT2 inhibition was sufficient even for an experimental tool, and that's why the 2 points go hand in hand, because in both cases, whether as a tool or to treat diabetes, you need a sufficiently good EC50 to be useful. So having summarised the background, the judge then goes to ask, what level of potency would the skilled reader think DAPA had, even if, contrary to our submissions on ground 1, they understood the patent as disclosing that it had in fact been tested. And he deals with this at 253 of the judgment onwards. And in 253, he points out that the patent does not disclose that any EC50 had been obtained, or even how it compared with that of fluorescein. That's the first point. And then in the 254, he says, importantly, nor on the evidence did the description of the assay mean that any positive result must have been an EC50 in a range which would confer utility. So not only are the results not given, but you also can't infer that the results are good enough to give utility. And crucially, the judge has based these findings on the evidence. And so we say it's just not possible for my learned friends to seek to go behind it. And in particular, on this point, it can't even be characterised as a point of construction in our submission, even if my learned friend was right about ground 1, which we of course say he wasn't. And that's because there was clear evidence from multiple experts that the EC50, which might have been measured, would have been in the millimolar range, or might have been in the millimolar range, and they agreed between them that that would be useless. And he records those findings in 254. Dr. Edwards said, and Professor Bailey accepted, that the potency could have been in the millimolar range. And then he goes, in the second half of 254, he goes on to deal with the submission about the reference to 10 micromolar, but he doesn't accept that based on the evidence, and he says it doesn't help anyway because it's still not useful. So he deals with the point about that. And then he goes on to say this is a bootstraps argument in 255, which it is, because effectively he's characterising AZ's argument is you have to assume it's been tested, and then you have to assume that if it's been tested, it must be good enough. And of course, there's no basis for that anywhere in the patent, and particularly when you've heard what the experts have to say about what these assays, what sort of results these assays give you and the ranges that might have been achieved. He refers to 2 passages of evidence in 256. My learned friend took you to that, and he said in relation to the first passage, oh, well, that's where Professor Bailey was being asked about the prior art. And it's right that I was discussing W0128 with him in that passage of cross-examination, but of course the wording in relation to the assay is identical in W0128, and so the technical answers he gives about results you might achieve apply equally. And indeed, when we got onto the patent, he confirmed there was no difference in relation to the technical aspects to the passages that he'd already been asked about, and there was no point in asking it all again if that was the case. And the second passage is another important passage. He again, this is where he's being asked expressly about the patent, and he picks it up from where we were looking at in the transcript earlier, the first 2 questions, and then I say, not only is there no scientific rationale to support any of the bare statements in the patent about SGLT2 inhibition, there's even less to tell you that DAPAG is effective as an SGLT2 inhibitor at a level which provides any utility, whether to treat diabetes or otherwise. The answer is we do not know the level, yes, or the potency, yes. We do not know how effective it needs to be, yes. We probably do not at this stage. So we say that evidence is absolutely clear. There's no basis for my learned friends to seek to go behind it, and it completely supports the findings of the judge. 257, the judge again refers to the evidence about EC50s. Again, my learned friends, we say, can't go behind that. And the point the judge is making there is that there was real evidence in the papers, the Tanabe papers, of EC50 results being obtained for molecules which showed that they were inactive. And so that confirms that even if the reader thought that something had been tested, that doesn't tell them that it actually has any utility, because you might get results that are too poor to be any use to you. So there was that evidence too. Then 258 deals with the fluorescein EC50. That really goes to the tool point. We probably don't need to dwell on that now, because we say the same result. You don't know whether DAPA is good enough to be a tool either, based on the evidence that the judge heard. And then finally in 259, the judge finds that it's not trivial that no EC50 value is given. Rather, he says it's significant. And again, this is based on the evidence that he heard from the experts, who told him that not only do you need to do the assay, but you need to know what the results are in the assay. And if you don't know what the results are, you can't tell whether the molecule that's asserted to have activity is active or not. And again, these conclusions in 259 the judge reaches are based on the evidence. It's a reason why the bootstraps point he makes is a good one. You can't lift yourself by your bootstraps in a situation where the skilled team is expressly looking for technical information which is not there. And there was plenty of evidence to support the judge's finding that the skilled team did require technical evidence. And so for all those reasons, we say you should reject ground 2 as well, and therefore also ground 3, because the judge was plainly right and entitled to find that the statements in the patent lacked plausibility based on the law as he was bound to apply it. So, my lords, that deals with grounds 1 and 2. I was then going to deal with the respondent's notice, but as my learned friend hasn't pushed the tool point, we probably need to take the court's time up with it.
Have you had a word with Mr. Clifford? He's pursuing it.
He hasn't. He didn't speak to me at lunchtime. I don't know whether he wants to. So if he says substantially, he doesn't think it makes a difference. Now, obviously, don't want to push if he hasn't taken instructions.
Well, can this be dealt with overnight?
Yes.
Let's
Right.
leave it for now.
I mean, it'll either be briefly argued out tomorrow or go away.
It's not going to take very long either way.
Yes. Thank you. So tell us at the beginning of tomorrow what the status of this issue is.
Great. So, my lord, that brings us on to the plausibility grounds. I don't know whether your lordships want to take a break.
Yes, let's do that. We'll come back in at 1:30.
Tell me if I'm going too fast. I'm looking for their reaction. So I'm definitely going fast. I have to slow down. Slow down on duty.
One of those on your desk.
Oh yeah. Are they the same people? Yeah.
The same thing.
Oh, I got them for. Did I get them for some? I had to do I got sort of RSI from looking at my phone too much. And
Stressful.
Yeah, so I got some stress balls to do some. Yeah.
I get little tingles.
Yeah, so I think I've got a little thing on the back of my phone now that if I'm holding it, it sort of rests. Yeah, but it's the main thing is you're on your phone too much. That's what it's telling me.
Yeah, if I get it here, I find I get a really sore neck.
Oh, you do it like that?
What would you? What you?
When you sort of get that, you feel it.
No, I find that I've got my phone out for a while, my hand starts tingling.
Yeah.
I think it's because I hold it still as well. It's an unnatural thing to hold your hand like that. Yeah. A little bit of nerve damage.
Stay in here or go out. There's so many people out there. I'm thinking it's not going to be cool.
sharing a chair?
No, just that, you're on that one. Yeah, sorry, I have spread out my papers on these days. You're on that one.
Oh, yeah.
It's so much hotter when you're actually talking. Yes.
Is it because the heat rises?
I thought that hot air leaving you.
Thank you. To make me cooler. The whole rest of the hot air's leaving me.
Yeah, warming the room up.
Lovely. Well, it's raspberry.
You said fun, you got both balance and
Are you being the trial?
Just finish the evidence.
Oh, cool. Are you on this? Me then one. Only just finished.
I did say I don't like men there.
Very short.
Very short indeed.
Does that make sense? Thank you.
Rise the tables.
So, my lords, I'm on to plausibility. Just some preliminary points, if I may. I just want to record or point out what the judge recorded early on in his judgment. This is paragraphs 34 to 36 and paragraph 38. And this is the question of what findings of fact he was being asked to make by Astrazeneca on the various alternatives that might be before him or indeed this court. And he records the toings and froings in 34 to 36 and 38. He does make an ab initio implausibility finding in our submission in paragraph 251. But he doesn't go on to make a finding based on the test set out in T116 of 18 for the reasons he gives in paragraph 262. We'll have to come back to that later. But the reason that he doesn't do that in our submission is because Astrazeneca didn't identify any further findings of fact, nor did the judge identify any that he needed to make, nor that he could make on the evidence before him. And so we say, to the extent that there are findings that are missing because the judge hasn't made them, that is because there was an absence of evidence or an absence of a request by Astrazeneca to make certain findings, and that is Astrazeneca's problem. We made this point before the judge at the trial, and the judge, we say, correctly recorded the interchanges between the parties as the trial developed in 34 to 36 and 38. But the whole question of plausibility does have to be understood with that background in our submission. Next, I was going to move on to Young and Bristol Aeroplane and AstraZeneca's attempt to say that apixaban is not binding on you. Now, although in their skeleton argument they had raised two grounds under bringing Young and Bristol Aeroplane for not following apixaban, they said per incuriam first of all, and then they said because of the EPO. My learned friend hasn't pursued the per incuriam point before you on his feet, and we say that's he was right not to do so because the rule in dupe and reliance is clear. There has to be an absence of a decision, which means the courts must have reached the the contrary decision had it available to it, and that is a non-starter in this case because self-evidently the court had G2 of 21 in front of it in the Apixaban decision, and it reached its decision about the standard for product claim in paragraph 92 of Apixaban with that in mind. And so we say the per and curiam point is hopeless, and that's no doubt why my learned friend didn't trouble you with it earlier. The alternative ground, which he did develop at some length, is to say that there has been a settled direction set by the Admiral, that is the EPO, and that the British ship is now sailing on an obviously erroneous alternative course to the rest of the fleet. And we say there is no basis for this for multiple reasons. Firstly, we need to look at G2 of 21, and we say that it does not give the guidance or the direction that my learned friends submit that it does. So if we can turn to that, please, first of all, it's tab 20 of the second authoritative bundle. I appreciate the court's looked at it once in Apixaban and looked at it again this morning, so I don't want to labour it, but there are a few passages that I think are worth picking up, if I may. Firstly, paragraph 23, which is on page 1116. And this wasn't a paragraph that my learned friend took you to this morning. And what we say is significant about paragraph 23, a number of points. Firstly, they refer to the fact that the assessment of inventive step is to be made at the effective date of the patent, that is the final date. And the second is they say on the basis of the information of the patent together with the CGK. And we note there that they refer to the Salt case, 609 of 02, and Johns Hopkins 1329 of 04. 609 of 02, of course, is a sufficiency second medical use case. Johns Hopkins 1329 of 04 is an obviousness case. So they're referring to both sets of cases when they refer to this basic principle in paragraph 23. And we can also see in paragraph 25 the thinking behind the objection to speculative patents. They say the technical problem must be derived from effects directly and causally related to the technical features of the claimed invention. An effect could not be validly used in the formulation of the technical problem if the effect required additional information not at the disposal of the skilled person, even after taking into account the content of the application in question. So again, we say that they're making it clear that the assessment that has to be done is limited to the application before the board or the court that's assessing it. And we say it's plainly not contemplated that, and indeed we see it later on, that something that isn't plausible can have its plausibility founded on material that is only available to the skilled person after the filing date. That would be counter to all of the principles in the EPO, whether that material is secret or put on a public file at a later date. Either way, it's only available after the filing date, and we say that's contrary to the principles set out in paragraphs 23 and 25, which run throughout the whole structure of the EPO. And we also submit that these paragraphs 23 and 25 reflect the patent bargain. They reflect the fact that you get a monopoly, but you only get a monopoly that you have made available to the world in your application. That same patent bargain is reflected by the Supreme Court in Warner-Lambert. And we say there's can be no doubt that everyone is applying the same principle and heading towards the same destination. The only question can be whether we're all taking the same route to get there or not. So that's the introductory section. If we could turn please to paragraph 58. This is, again, before they turn to the jurisprudence. I don't think my learned friend showed you this earlier. Perhaps your lordships would just remind yourselves of paragraph 58. And so we say that in this paragraph, it's clear that the board are accepting that the concept of plausibility is an important one. And the reason that it's there is because you have to have a criterion for reliance on a technical effect. And you need to show that that technical effect is real and not merely asserted. And so there's nothing we say, although the final wording in this case doesn't use the word plausibility, and it may be that the board were deliberately trying to avoid using the word plausibility because they wanted to try and set the test up without using a word which is perhaps more difficult to understand or perhaps causes problems with understanding. They're not saying that the concept is wrong, and indeed they refer to the concept here by general reference to purported technical effects. And of course, as your lordships have heard, a purported technical effect is important not only for inventive step when you're carrying out the problem solution approach, which the EPO does, but it's also important for sufficiency where the purported technical effect in the EPO is part of the claim and needs to be satisfied that way. In both cases, you are having to assess whether the technical effect has been achieved, and it's just a case of whether it's as part of the claim language itself, or whether it's only part of the problem solution approach that you do so. But in neither case, we submit, is the board casting any doubt that the concept of plausibility and the concept of achieving the technical effect is the right one to pursue. Then the board deals with the two lines of case law, and my learned friend took you through that earlier, and we see the two grounds, two types of case law which are reflected in the questions, the ab initio plausibility and the ab initio implausibility cases. And I don't think I need to labour those passages. If we go, please, to paragraph 71, this is where the board seeks to draw together the two lines of case law. And they say, line 4, the enlarged board understands from the case law of the board's appeal as common ground that the core issue rests with the question, and then they set out the question which my learned friend took you to previously. So again, they are seemingly seeking to suggest that all of the cases are trying to do the same thing, and that is apply this principle, albeit they may have done it using different wording. And then, as my learned friend took you to in 72, they state expressly that they are satisfied that the outcome in each particular case would not have been different from the actual finding of the respective Board of Appeal. And in that, they seem to be saying that even though different language is being used in these different cases, the outcome is the same. And if I may, Lord Justice Jackson's observation earlier that all of these cases are all matters of fact and degree, and it may be you can say you can use different language in one case to another. If the result is the same in each case, we say that the boards are applying the correct approach, and it may well be that you can express that test in different ways in different cases. But it doesn't mean that they're doing something different when they're
Mr. Hinchcliffe's submission is that the only way you can reach that conclusion is if what they're doing is levelling down.
Yes, but that cannot harmonise, my lord, it can't be right. If you were levelling down, then that would lead to the suggestion that Johns Hopkins, for instance, was decided the wrong way, because Johns Hopkins was decided on an ab initio plausibility standard, and if you're levelling down to ab initio implausibility, it might well be said that the molecule in that case was a member, or was plausibly a member, or not, was not implausibly a member of the beta family. And so it's very difficult to understand paragraph 72 and the conclusion that each case is rightly decided.
Right. So on that analysis, what the enlarged Board of Appeal has done is to fail to reconcile the irreconcilable.
Well, the way to reconcile it is, as my Lord Justice Jackson suggested this morning, to say, well, each of these cases is a matter of fact and degree, and the board got it right each time. That's the way to reconcile it. We don't understand how you can reconcile it by saying that the correct standard is ab initio implausibility, because that would mean that half the cases have been decided on the wrong basis. And it is. I accept it's not easy to see what the board is trying to do here, but it can't be right that they're intending to impose a test of ab initio implausibility and at the same time say that all the cases that were decided on the basis of ab initio plausibility were correctly decided. It just doesn't seem to make any sense. What they instead seem to be doing is trying to put forward an umbrella test which covers all the cases and which they say here means that all of the cases were decided correctly, regardless of the particular language that's being used. So we say the take-home point from paragraph 72 is that the board were not trying to change the law, because they were saying that each of the previous cases, which they have been through at some detail, was correctly decided. And so when they go on in 72 to say, the cited decisions, this is the last 5 lines, the cited decisions appear to show that the particular Board of Appeal focused on the question whether or not the technical effect relied upon by the patent applicant or proprietor was derivable for the person skilled in the art from the technical teaching of the application documents. They must be imbuing some sort of plausibility standard into the word derivable there. They cannot be suggesting that it's simply a disclosure test. Because if it was simply a disclosure test, you wouldn't need to look at plausibility at all, and you could just look at the assertion. And even my learned friend doesn't go so far as to suggest that the assertion in paragraph 14 of his patent is good enough for him to succeed. So somewhere in the wording that the board have arrived at in 72 must be some notion that there is plausible derivability of the invention. It must go further than simply a matter of the text.
What's the definitive language of EPO rulings?
Definitive language is the language of the patent. In this case, it was an English patent, I think, so they are translated into German and French as well, but the language of the proceedings. Right,
so this is, as it happens, pure point of curiosity, this is in fact the original language of this decision.
It is, yes. And my own friend points out the language of the proceedings on the front of the...
Yes, I think the point that you mentioned, which struck me earlier on, was not so much that every case depends on its facts, but more that you seem to be making the point here that because they don't endorse the concept of plausibility as such, that they're not so concerned to promote one sort of plausibility or implausibility and stamp out the other. And this may be, I was only speculating, but because it might make very little difference in almost every case, whether one considered implausibility or whether one considered plausibility and worked on from one of those standards.
But the problem is, it's a question of the burden of proof. Who bears the onus? Is it the patentee to show that what's in the application document is sufficient to make it plausible, or is the burden upon the opponent to show that what's in the document is implausible? And that's where the Supreme Court in Warner-Lambert divided, because the majority placed the onus on the patentee to show that what was in the patent made it plausible, whereas the minority said, no, you've got to show that what's in it is implausible.
And it may be it's a shifting burden, depending on and it may be, well, we talk about a legal burden or an evidential burden, and those concepts may not be as familiar to in the EPO. And of course, in the EPO, some cases they don't have an opponent.
Of proof. It's free evaluation. Quite seriously, literally, they do not have a burden of proof. It's wholly contrary to the civil law principle of free evaluation of evidence. The court is not bound. It evaluates the evidence freely of its own accord. There is no burden of proof in our sense.
Indeed, my lord. But the other point I was making was that in some cases, of course, in the EPO there is no opponent. So it doesn't make any sense, even if there was a notional burden of proof. It may just be the patentee against the office when you're trying to get your patent granted, and you go to an appeal to try and persuade the Board of Appeal that the examining division got it wrong. So there are different circumstances in different cases depending on whether it's an opposition or an appeal from the examining division. So, my lords, 72 says what it says, but we say that it's not right to say that this is a levelling down provision, and we say that's supported by the observations they have in 73 onwards about sufficiency, and the reason that it's appropriate to, even though there was no question of sufficiency before the board, and the board, as you would have gathered from seeing the early part of the decision, they have a very strict approach to admissibility in answering questions before them. And so there was no question of sufficiency before them, but they obviously thought it was appropriate to address sufficiency, at least to this limited degree in 73 onwards, because so many of the cases in which plausibility has arisen are sufficiency cases, and therefore we say it was appropriate for them to do so. And it's notable, and as my learned friend rightly accepted, the passages on page 53 of the decision, page 1141, where they refer to the decision 60902, are you can't get a cigarette paper between that and the decision of the Supreme Court in Warner-Lambert, where they set out the tests and set out the standards. So to that extent, the enlarged board were agreeing with Warner-Lambert, and they did not suggest that it was wrong to have this test for credibility in the sufficiency test. And if we go, please, to 77, which is where they set out the test on sufficiency. They use the word credible, three lines up from the bottom, and we say it would be very strange if they were somehow seeking to impose a different standard for inventive step. You would have thought they might have said that had they been intending to do that, and they don't. The other point to make from this is my learned friend tries to make something of the use of the word narrower in line 3, where they say the scope of reliance on post-published evidence is much narrower under sufficiency of disclosure. And in our submission, the simplest way of understanding that is that sufficiency case, the requirement to look at plausibility in sufficiency cases is confined to those cases where the function is written into the claim or is a therapeutic use. Then your opportunity to rely on post-publish evidence is narrow because it's only in a limited number of cases that these sorts of claims appear. And we can see that reflected, if your Lordship just turn back to paragraph 1, to page 1109 in the bundle. This is recording the arguments of the parties, and 1109 is addressing the argument of the patentee, and they say, first full sentence on 1109, thus the threshold for sufficiency of disclosure should normally be addressed by the applicant, so that is addressing who is to address it. And then they say, with regard to inventive step, however, it will be highly unpredictable which technical effect the patent applicant should rely upon, as the discussion of the technical effect depended on the choice of the closest prior art that is usually introduced after the filing date. Hence, the applicant would often be forced to argue for a technical effect of a distinguishing feature not focused on when filing the application. So what the patentee was arguing there is because the problem-solution approach, which the EPO adopts, depends on identifying the closest bit of prior art and then comparing that with the patent. Because you don't necessarily know when you're filing your patent what the closest bit of prior art is, you can't always be expected to have to guess what contribution you're going to have to prove when you get to the opposition stage later on.
So the argument is that we solve one problem, viz. That hindsight is introduced by problem solution, by introducing another problem, which is we say, okay, you can allow hindsight in the form of post-filed evidence.
Well,
One answer might be, let's have no hindsight at all.
Indeed, my lord, and we, of course, the problem-solution approach is inherent in the EPO, and this is why there is a difference of approach in the EPO to inventive step and sufficiency. And no one on that side of the court is suggesting that we should all be adopting the problem-solution approach in every case in the UK. So it's not a case that we have to be in lockstep with the EPO on everything. But if you are going to adopt the problem-solution approach, then that does bring with it the burden that you then have to work out the technical contribution compared to the closest prior art, and that may change. And indeed, as my learned friend alluded to, you are also allowed in the EPO to change your technical contribution if a new bit of prior art arises, and then that leads to further issues. So in our submission, when the board was referring to the narrower scope for sufficiency of disclosure in 77, they were just reflecting the fact that you are confined to the function that is set out in the claims when you're trying to address plausibility or credibility or sufficiency. But of course, when it comes to inventive step, the scope is much broader because you have to look at the closest prior art, and you may not know that when you're filing your patent, and that's why it is broader. So, my lords, that's why we say that this finding in paragraph 77 doesn't undermine the notion of the burden, what the appropriate burden or level of proof is for inventive step. Then the board go on and look to the national case law. They go to Warner-Lambert, as my learned friend took you to. They certainly don't say it's wrong. Indeed, they say there's a degree of common ground when they come to 87. And then we get to the final concluding considerations, 88
Yes,
onwards.
but how much does that help in circumstances where Warner-Lambert was a sufficiency case? And I appreciate you giving your arguments on sufficiency a moment ago.
Yes, I see. So to the extent that Warner-Lambert is right about sufficiency, there's common ground, all right? They may have been saying that. But they certainly don't. In the light of my learned friend's concession that the standard here is for sufficiency is the same as Warner-Lambert, maybe that's all they were meaning. But they certainly don't say the Supreme Court were off on a frolic of their own in applying the standard they did in Warner-Lambert, which we say is of course correct. So the final passage, 88 onwards, we say it's fairly apparent they're trying hard not to use the word plausibility in this section because they're trying to move away from that as being the key word, even if they accept that the concept should still be there. But they do link back to what they said in paragraph 72 and what is the question of what is derivable and the observation that all the previous decisions stand. And we say that means that they, again, not trying to change the law, but they're trying to instead provide a unitary test which can be applied.
Just pause a second, would you?
And my lords, paragraph 92 we say is significant because they do in paragraph 92, they refer to plausibility and they refer to both articles 56 and 83. And they again repeat, it rather describes a generic catchword seized in the jurisprudence of the Board of Appeal by some national courts and by users of the European patent system. They're certainly not saying there that it's wrong to have a notion of plausibility for Article 56, but it's right to have it for Article 83. And you'd think if they had meant that, they would have said so. And then in 93, they emphasise what the skilled person would understand at the filing date. And then the last sentence, the technical effect relied on even at a later stage needs to be encompassed by that technical teaching and to embody the same invention, etc. Now, when they say at a later stage, in our submission, they're not saying that you're allowed to rely on material or the test changes and you can bring in later material. What they're saying is the technical effect you may be relying on at the time your patent is being opposed or it's being litigated in a national court still needs to be encompassed by that technical teaching, etc. So there's no slippage or no loosening of the requirement that everything that you get your monopoly for needs to be contained within your patent at the filing date.
Just pause a moment, would you? Sorry to interrupt you.
And so, my lords, we say there's no weakening of the principle that everything needs to be understood as at the filing date, even if the debate is being had some years later. And then in 95, they expressly acknowledge the abstractness of their criteria, and then they give us the test in paragraphs 1 and 2 of the order. We note that the word derive is included in paragraph 2, and for the reasons I gave earlier, that cannot mean just be disclosed. There has to be more to it than that. It has to be disclosed and be believable. And so even if the board is trying to move away from the word plausibility, because of their acknowledgement that the cases and the decisions decided previously must all stand, we say that the notion that the technical effect you're relying on for the purposes of inventive step has to be contained within your application as filed and has to be believable in that application and supported remains. And therefore, we say that although the wording of the test might have changed, the standard and the overall law to be applied under it has not, and that was not the intention of the board as they expressly made clear when they said that all the previous decisions must stand. So, my lords, that's G2 of 21, and we say it is far from giving guidance which suggests that the UK approach is out of kilter with anywhere else in Europe. Indeed, we say that the approach adopted by the judge in this case and by this court in the Pixaban is entirely consistent with the guidance that the EBA has set out, and therefore there is no requirement or reason for any further court to have to look at this as a result of this decision. So, my lord, the two places I want to go to see how this has been applied are when this case returned to the TBA, that's 116 of 18 in the next tab 21. And again, my lord, my learned friend took you to this, so I can do it relatively briefly. If I can pick out a couple of passages, please. Firstly, on page 1176, and this is the start of the analysis section. And at the end of paragraph 11.1, the TBA sets out the policy underlying the questions to the board and the approach of the board in giving the answers. And the policy is clear. It's intended to prevent the filing of applications directed purely to speculative armchair inventions made only after the filing date. So although we inferred that from paragraphs 23 and 25 of the enlarged board, it's clear from the TBA here, and indeed that's the reason they asked the questions in the first place, the purpose is to prevent speculative armchair inventions. So there is no question that the EPO is intending to stop people sitting in their armchair and writing a patent without knowing whether or not what they're suggesting works, or without presenting to the public evidence as to whether or not what they're suggesting works. And we say that's an important, very important part of what follows. And the further thing which must follow from this is that the patent application must be more than just a literal disclosure of the alleged invention. Because if all that was required was a literal disclosure, then armchair patents wouldn't be prevented, because you could just write out a molecule, or you could write out a medical use. And so again, what is clear is that derive, as used by the enlarged board, must mean more than just literally understand. It must encompass some degree of credibility or plausibility or reason. Because otherwise, if it was just you can write anything out and you can derive it because you can read it, armchair patents would be permissible. So that's 11.1. 11.3.2, after setting out the test, they acknowledge that the wording may be more challenging to understand, and then they say, just level with this bottom hole punch in 11.3.2, they say, the enlarged board may have chosen to do so for two reasons, namely either because it considered all three plausibility standards to be wrong and wanted them to be replaced, or because it considered all three standards to reflect the same requirement and wanted to condense this requirement as defined. And they don't answer that, but we say it's plainly not to be understood from G221 that they were throwing all of the decisions out the window. On the contrary, we say they were wanting to condense the test to a single test. If they had been wanting to throw them all out, they would have said they were all wrong, and they didn't. Then, if we go on, please, to 11.11, this was a passage taken to you by my learned friend. This is where they set out the legitimate reason to doubt test. And we say it is inconsistent and surprising to first of all acknowledge that the board wanted to change it up and not use one of the previous tests, but then it's rather therefore surprising in 11.11 that they seem to alight on the legitimate reason to doubt test as being the one to apply in this case. And we say that was a mistake by this board, and as can be seen from some of the later authorities, that there is good reason to doubt whether that was what the enlarged board was intending when it gave the decision it did. They then talk about 11.12.1. They talk about the later stage wording that we've looked at in point 93. And we say that, again, with the greatest respect, they've got that wrong. That wasn't meaning to suggest that you can rely on a different technical effect based on a later time point. You still have to find the technical effect in the application as filed. And the board has gone wrong here to the extent that it interprets at a later stage to mean that there's no need for data. You still need to find a basis for the alleged technical effect in the application as filed. And we also say in 11.12.3 that they have misunderstood the narrower wording. This is the top of page 1182. The broader, narrower point, which is used as we saw in point 77, and I've explained why we say the more natural understanding is because of the submissions of the patentee and the fact that you might not know what the technical effect is if you have got a new bit of prior art that you weren't aware of at the time you filed your patent. Then in 1186, we note that the TBA in 116 of 18 appears to disagree with the Dutch Court of Appeal. So this is referring to the apixaban case at the top of 1186. And so even as between the cases that my learned friend relies on, there seems to be some...
Sorry, you've lost me. Where are you?
So I'm top of 1186 of the bundle.
Thank you.
Sorry, it's confusing. So they're discussing the Dutch Court of Appeal preliminary injunction decision in apixaban. And they seem to have a different interpretation, which is perhaps unsurprising given what we'll come to look at, but we point out as we go through. And it's no doubt right, this was one of the very first decisions of the TBA following G2 of 21, because it was the decision that led to the reference. And it's right that this case has been cited on occasion in other cases, and my own friends put a couple in the bundle. But it's also right that there is a very different view about the effect of G2 of 21 coming from another board, and that's at tab 22. And this is the case that was before the judge, so again, I don't need to spend too long on it. But your lordship can see it's board 3304. This is the first page of the decision on 1211. And that is the main pharmaceutical biotech board. And lordship will note it's a pharmaceutical proprietor seeking a patent, multiple generics opposing. And although the date on the top of the decision is November 2023, in fact, this written decision wasn't handed down until December 2024. So they took a long time to write it. It's right that it hasn't yet been cited on many occasions by other boards, but that's because it's only pretty recently been published. And so, although...
So just to explain that, my understanding, and correct me if I'm wrong, is the reason for the date is there will have been an oral decision at that date.
Yes.
For reasons to be given later, as is almost universal practice
Yes.
in the boards of appeal.
Yes.
So that's the reason for the date made. The other point to note, which may possibly explain the timing, is that of course this board and the board deciding the previous decision have one member in common. And of course, like any board of 3 members, it will be a majority decision.
And I should say, my lords, and I was going to come to this later, that just for your lordship's note, because of the delay in handing this decision down, and because the previous decision wasn't the subject of debate at the oral hearing, one of the patentee in this case has applied to the EBA for review under the article, the procedural irregularities rule. So this case is still alive, but the preliminary opinion of the EBA is that there is no procedural irregularity, because they say that there was proper argument about all the issues before the board, and therefore they are proposing in their preliminary opinion to reject the notion there's been any breach of Article 113. But your lordship should know that there's a hearing due in September in that case. Anyway, back to the substance of it. On page 1228, they set out 3 challenges right at the bottom of 1228 in interpreting point 2 of the order of G2 of 21, having reviewed G2 of 21. They say, firstly, that the terms encompassed by the technical teaching embodied by the same originally disclosed invention are not used in the case law, and therefore remains to be seen what they actually mean. Then they say, point 2 on page 1229, they say the enlarged board didn't expressly define these requirements, and that's right. And finally, at the bottom of the page, they say the purpose wasn't set out by the enlarged board. And then they go on to review decision 116 of 18, which, as your lordship has pointed out, has a similar member of the board in common, one member of the board in common. And they say, as far as the relationship goes, this is para 6.13.2, that the 2 points from G221 are cumulative and separate. They agree with that. Then they agree with the purpose of the ruling, and that is to prevent speculative inventions. And at the bottom of page 1230, they say it's intended as a safeguard to ensure that only inventions already made and disclosed at the filing date are granted patent protection. And then they go on to deal with the content of the requirements, and they set out a long passage from T116 of 118 from page 1231 onwards. And they go on at page 1234 of the bundle to say that there are 2 issues of interpretation of the passages in T116 of 18. First, they say, this is 613.6, there's an inconsistency in the reasoning. And then they say in 613.17, they refer to the ab initio implausibility test. And they say 613.8, they've adopted the ab initio implausibility test, even though they were meant to be saying that both lines of case law were valid. So they identified that problem. Then in 613.99 on page 1236, they say some of the inferences drawn in the passages are not supported, and they say there's a question of the support for the legitimate reason to doubt, and for the suggestion that no positive statement is required. That's little b. And they go on in 6.13.11 to question whether it's really correct that the technical effect might not need to be literally disclosed, and whether they question whether derivable might mean the same as directly and unambiguously derivable. That is the test for novelty that's applied on a daily basis in the EPO. And then finally at 6.14 on page 1239, they apply the principle, and the principle of trying to prevent speculative applications. This is the passage that's quoted by the judge, just by the second bottom hole punch. Such speculative applications arise where either the existence of the claimed technical effect or its generalization is speculative. This may occur because relevant data have not yet been generated, or, if available to the patent applicant, have not been disclosed in the patent application. And we say that, if that's right, that puts paid to the suggestion from my learned friend that the solution is to file all your data later and then put a note on the front of the patent that there is later data somewhere on the file. That would not meet the requirements of having made the invention at the filing date. You're only making it at a later date, and that would contravene that principle. Finally, your lordships would note at page 1253, there was a question about whether there should be a further referral to the enlarged board to try to clarify the scope of its ruling in G221. And in paragraph 18, one of the reasons that they said there shouldn't be a referral is because there was not yet no such divergent lines of case law are apparent. So as far as the boards are concerned, there's not a divergence yet, even though we see these questions being raised and serious questions being raised about whether or not T116 of 18 is the right approach.
Yes, but the point against you there is that that's a recognition that although they had trouble with the reasoning in 116.18, it was overturned because on the facts it didn't matter.
But that may be, but there's certainly, it's also, they've certainly raised points of principle here about what does disclose or what's derived will mean, and plainly those have not yet been resolved. And you need to have a series of cases.
Yeah, but that then leads on to Mr. Hinchcliffe's challenge to you, which is, are there any others?
Right. Well, we've only got the ones in the bundles. I've obviously no reason to believe if he said he's looked at 60, but this is, as for the timing reason I explained earlier, this has only come out relatively recently. It is a major decision in our submission, and it will take time for it to feed through.
Yeah, on that question, I should have asked the question earlier, I apologise. You've referred to the fact that it's quite recent, but is it possible to identify the actual date of publication? I mean, obviously it doesn't appear on the document, that's for technical reasons.
Yes, I had to go onto the file to find out when it was sent to the parties. It was December 24, but I will check that overnight and let your lordship have that. So the other area which my learned friend seeks to rely on is the national case law for other EPC states, most of which are concerned with a different factual matrix of the Apixaban case. And the first point we'd make on that is, of course, none of the national courts represent the admiral who is meant to be leading the fleet. And indeed, the fact that one or two of those national courts may be steering a different course to the rest of the fleet is not a matter for the courts of this country if we are still following the admiral. And in our submission, if one looks at particularly the Dutch decisions, we suggest that it's the Dutch court which is not following the guidance of the enlarged board, not the courts of this country. So let's look at that decision first of all. So we're going to tab 30, which is the decision my learned friend took you to this morning. It's the interim injunction decision in the Apixaban case. And if we can pick it up on page 1372, and again, my learned friend took you to most of these passages this morning, so I won't labour it. But if we pick it up in paragraph 6.8, we say it's clear from the first sentence of 6.8, where they say the application already includes evidence that the alleged technical effect actually occurs, or that this is made plausible in the application, as Sandoz argue. They are there rejecting the notion that the invention needs to be made plausible in the application. So they're not just deciding whether it's ab initio plausibility or ab initio implausibility. They are there rejecting the notion there needs to be any plausibility at all. And we say that is completely wrong and plainly inconsistent with the understanding of G221, which I've shown you, and which both boards following G221 seem to accept. They go in 6.9 to refer to the different standard sufficiency and credibility. And then they reject that in the last sentence of 6.9 as being applicable to inventive step, but they give no reason for why. It's just a oh, we don't think that's right, but they don't explain why that is, and we say it's very difficult to understand. And then in 6.10, which is one of the paragraphs my learned friend didn't take you to, they say it follows that the technical teaching should not be understood as what is learnt on the basis of information, including the application to the expert about how the technical problem has actually been solved. And they say instead, it's the question is whether the technical teaching is understood as how the technical problem can be solved with technical resources. So they seem to be suggesting all you need to do in your patent is suggest that the problem might be solved.
Well, the reader of the patent can make the invention.
Well,
wonderful.
Indeed. And this really, one can see in here a reflection of what Lord Hoffman said in Connor, paragraph 28. You shouldn't get a patent for suggesting that something might have an effect. You need to actually, the technical contribution has to be actually solving the problem, not just putting one forward. And so when we get to 6.12, it's just, in our respectful submission, very difficult to understand why the Dutch court seem to think that the ruling they're giving doesn't lead to a free pass for speculative patents. Because what they say is, after all, the fact that protection is granted based on a purely speculative patent for an invention that is only made afterwards is prevented because it's required that the technical effect is already included by the technical teaching in the application. But if all you need to do is write down what your invention is without making it plausible in any way, then you can get a speculative patent, and it's very difficult to see how the Dutch court is determining that you wouldn't. And the only reason the Dutch court gives as to why speculative patents would be not allowed is the reason in the second sentence, and the third sentence, which is that they had in fact established in that case that it was not a speculative patent because there was evidence, previously secret evidence, that the inventors had already determined the affinity. So, my lord, we say that the Dutch approach seems to allow for speculative patents, except if you can prove that you have really done the work, and you can come up with evidence of that work after the event. And we say that completely undermines the principle that the first to file should be the person to get a patent, because if that was the case, no one would ever know whether or not a patent was speculative or not until you had a court case many years later. And if you don't have to do the work before the patent's filed, but you can do it in the year afterwards, or indeed any time after, then of course you can get speculative patents and only make your invention as a later date, contrary to the principle of first filing. So, my lord, we say it's just not clear how this Dutch test is meant to work and meant to prevent speculative patents, other than by requiring a disclosure exercise every time there's a litigation to find out what had really gone on around the priority date, a bit like the Americans do, and that would be a recipe for disaster in our submission. So, well, that's the Dutch decision, and then we have there's the.
You're referring to the position prior to the American Events Act.
Yes, I was.
They've gone on over to first to file, like we have, in order to avoid interferences. Among other reasons.
Then we go to tab 32, which is this is the also the Court of Appeal, and this is where in Holland this is in fact a decision going the other way. And if we look at it, can we pick it up please at page 1423? This is where the court sets out the two differences. This is at bottom of 1423. This is the two possible differences in the problem solution approach, 1 and 2. They reject 1 in 5.2 because they say the prior art discloses that, so 1 is wrong. And then they're looking at little 2, which is whether or not the tablet is manufactured using dry granulation. And they say in 5.3 that the opponent repeatedly pointed out that the problem that Gallianicium believes to have resolved with EP 187 only took shape in the course of the granting procedure. And the question was whether or not the application distinguished dry granulation from direct compression. And they go on to hold, just below the bottom, hole punch. Contrary to what Gallianicium argues or suggests, the words more preferably in the last sentence of the cited passage do not indicate that dry granulation is preferred over direct compression. And so, if your lordships go to 5.6, they determine that there is no disclosure in the application that dry granulation has better properties. So we say it's fairly clear from this that the Dutch courts are applying a disclosure test, applying G221, and for all the reasons that I went through earlier, we say that's plainly not the right test, because if it was a pure disclosure test, you could get yourself an armchair patent. And the reason why it's wrong, it can't be a disclosure test, is that anyone could sit down and draw structures falling within the marquoosh of W0128 and file patent applications on them. And you could only do the testing at a later stage and find out which are worth pursuing to grant after having filed the application. But that would seem to satisfy the Dutch court, because if it was said in the application this molecule has activity, that would appear to be enough, even though that would not cure the mischief of trying to prevent speculative patents, unless the crucial step is also proving to the court that the work has been actually done prior to filing, which is what the court seemed to look at in the Pixaban case. But that would make no sense from a policy perspective, because it would allow both speculative and non-speculative patents to remain on the register without the patent having any idea which are which, until expensive litigation required the patentee to make available its secret information many years later. So, my lord, we say that's why that approach can't be right. And of course, we point out that in this case, AstraZeneca quite rightly did not seek to rely on material showing what it had or had not tested before the judge.
BMS again.
Well,
they acquired it from BMS.
Yes, but in the trial before the judge, AstraZeneca, quite rightly, we say, based on the policies we'd be looking at, did not seek to rely on material showing what had or had not been done prior to application for the patent. Lord, I appreciate it's 4:30, and
Yes.
It's been a long, hot day.
Yes, thank you. Now, tomorrow, I've been a bit puzzled by the timetable that you agreed, because respondents don't take as long as appellants for obvious reasons. But you appear to have built in 2.5 hours tomorrow morning, which I don't think you're going to need.
I shouldn't need that, my lord, no. So I
or
don't know
anything,
whether you would like to
or
start.
anything like it. So we'll start at 10 o'clock, in order that we shouldn't be under pressure, but we're not going to be able to run beyond 1 o'clock in any circumstances.
Yeah, there won't really need to, as far as I'm concerned.
Thank you very much.
Right, so